only ingress egress route. So if that is blocked,
can I go ahead and read the one from the Packmans, if that's acceptable to y'all?
Okay, so we can go ahead and do that. But I'd like to just make sure that we try and stay, not be repetitive on things that have already been mentioned. And I think that that we have mentioned quite a bit, and relative to other speakers, if instead of being repetitive and just trying to be cognizant of everybody's time, it's about getting close to 9:30 now. If we can just, if the statements are somewhat repetitive, you can just say that we agree with the statements that have been made by Mr. and Ms. Terhune, and stand in opposition or support, whatever it happens to be. But if we could try not to be as too repetitive on things that we've already been presented to the board, I'd appreciate that. So go ahead, Mr. Jim Terhune.
Yeah, this is from Paul and Sandra Packman, and they've sent it to me. They're at 5 Coyote Hill Lanes. They actually are in Texas right now, but it's very short, but basically they agree with everything that we've written. They helped us write all of that. Bottom line, they expect that these changes, they continue to be respected and adhered to. They're disappointed that the code is being basically very bad precedents for being violated, and the letter and the intent of the 2016 SOEC. Bottom line, they request, along with our other fellow landowners, that serious consideration be given to the impact of the granting these variances on the environment, the flora, the fauna. They remind us that there is, this is an archaeological cultural zone, medium to high. There's a pueblo 2 miles away. Civil War was fought 16 miles away. We are in an archaeological cultural region, medium high, where we don't seem that to be talked about. We brought that up many times. Thank you.
Thank you, Mr. Terhune. And can you just please state the names of the for the email that you just read for the record as clearly as you can?
Yeah, Paul and Sandra Packman.
Thank you, sir. Lanes. Appreciate that. Tessa, can we have our next speaker, please?
Yes, Mr. Chair. Our next speaker is Ann Lehman.
Hello.
Yes, go ahead, sir. We can hear you.
Yeah, this is Alan Suits. I'm the husband of Ann Lehman. I live at, do you want me to swear in?
Yes, please.
Okay.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
For the record, before you testify, please state your full name, address, and that you understand you are under oath for your testimony to be considered valid.
Yes, my name is Alan Suits. My address is 43 Coyote Mountain Road, Santa Fe 87505, and I understand I am under oath.
Thank you.
Okay, I guess what I would like to say at this point is I am still kind of stunned at the statements from Mr. Walton that they have to have variances first before they can show us any valid plans, and I can't even wrap my head around that. Okay, let's let that go. Here's the only thing I would like to emphasize at this point. I've lived here for 20 years, and I've seen numerous incidents of dramatic and destructive runoffs over the years after heavy rains on our dirt road. The worst runoff is directly from the 2 washes that are right in the center of the proposed building site. Our community statements about this early on in the hearings with the County Planning Commission were dismissed as anecdotal. I was kind of shocked, and I don't want to belabor this anymore, but we have been really astounded at the lack of professionalism and courtesy and decency shown us by the County Planning Commission, not to mention that they have ignored, dismissed, and evaded an enormous amount of our questions and concerns. If the applicant is willing to resubmit accurate, detailed, and legitimate plans for building on the site in question, we could revisit the whole subject of granting variances. but there is no valid reason based on the dishonest and misleading plans and documents the applicant has previously submitted for any variances to be considered at this time, as far as I'm concerned. That's it. Thank you.
Thank you, sir. Can we get our next speaker?
Susan Kennedy.
Hi, it's Susan Kennedy Zeller. It's a double name, please. My correct name, okay?
Hi, Susan. Could you speak up? It's very hard to hear you.
Hi, I'm Susan Kennedy Zeller.
Zeller. Miss Kennedy Zeller, would you please raise your right hand?
Are you kidding me?
Zeller, my legal name is a double name.
Kennedy Zeller, yes?
Yes,
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I have my hand up, and yes, I do.
For the record, before you testify, please state your full name, address, and that you understand you are under oath for your testimony to be considered valid.
Susan Kennedy Zeller. I live at 71 Coyote Mountain Road, and I understand that my testimony will be truthful.
Thank you.
Go ahead and go.
Go ahead, Miss Kennedy Zeller.
Okie dokie, thank you. Okay, issues I would like to emphasize concerning the proposed construction at 66 Coyote Mountain Road. And please refer again to the legal survey our representative Jim Terhune has shown you, and sent to you actually too. I live at 71 Coyote Mountain Road, and my property will be severely impacted by destroying this landscape and the actual construction proposed. The destruction concerns the use of my upper roadway that runs from the security gate past the developer's land and continues up to the higher curve where my property ends. The security gate was installed to prevent excessive public sightseeing to the mountaintop and has been maintained by myself and the Terhunes. This roadway, as you can see by the presented legal survey from Jim Terhune, actually is primarily part of my property. There's a very small, short slice along the bottom of the hill where the developer's property begins. My property ownership runs from the gate along the outer edge of the mountain on one side and the inner edge on the other, past the developer's land and continues up the hill until it reaches the Terhunes. I have never restricted the developer using this roadway to view or access his property. However, construction machines, trucks, heavy materials, an entire worker crew, possibly a number of worker cars, porta potties, floodlights, and everything involved with any construction traveling on or to this property is another matter. The roadway is fragile, and this excessive amount of construction will destroy not only the environment, as the Coyote Mountain community has indicated, but also my personal roadway property. All current owners above the data continue to maintain it. We also pay our share of the lower Coyote Mountain roadway, as do all homeowners contributing funds in proportion to their property's distance from the main road. Guess what? The developer to date has contributed nothing in the way of maintenance to either lower or upper roadways. Should this committee approve this construction, they must stipulate that all damage caused by construction be the financial responsibility of the appellant, and a regular maintenance share also be the responsibility assumed by any future owner. Lastly, water, as everywhere in New Mexico, is always a consideration. Our community has their own wells and monitors them carefully. Should this construction interfere with any existing water supply, it is 100% the developer's financial responsibility to remedy. If this committee approves this construction, your approval must stipulate these permanent maintenance responsibilities, monitor acts of construction, and protect it for the land and for the road. Thank you.
Thank you. Okay, can we get our next speaker, Tessa?
Mr. Chair, that was our final speaker on this case.
Okay.
Mr. Chair, before you go any further, can I add a couple more comments in?
Absolutely, Mr. Lovato, go ahead.
Thank you, Mr. Chair and Commissioners. I just wanted to clarify too as well that significant trees that the appellant brought up, those are trees that are located on 30% slope. What's been accounted for is on 30% slope, and I think Mr. Terhune referenced a visual that showed trees that were in the general location of this that were not on 30% slope as well. And to the second part of this is I really understand the points that were made just recently. It would be in the best interest if the applicant, property owner, Mr. Olson, had access to the top of his site, then we wouldn't be here in front of you for any variances. But in order to construct any residence on this property, variance request is required and needed to be granted. So I just wanted to put those out there. Thank you.
Thank you, Mr. Lovato. Okay, so we don't have any other public comment. So we're going to go to commissioners, and this is Commissioner Hamilton's district. So I'm going to go to Commissioner Hamilton first.
Thank you, Mr. Chair. Mr. Lovato, can I ask you a few questions to get some just clarifications on the record? This is a private residence that's being built on a legal lot, intended to be built on a legal lot of record, correct?
Mr. Chair, Commissioner Hamilton, that is correct.
And so the issues here, is it unusual to request the needed variances before detailed building plans are developed?
Mr. Chair, Commissioner Hamilton, in terms of the residents, we see these a lot. And what we try to do is we try to get the best detailed plans we can get. In this case, they were engineered plans. Sometimes we ask, more detail in terms of if they were requesting a height variance or so. But in this case, this is where we're at.
So my understanding is that you all went out to pick an alternate site when there was no access available for the building site at the top of the slope.
Mr. Chair, Commissioner Hamilton, sorry, go ahead.
No, well, it's kind of a double question, and went out to pick one that minimized disturbances, but still allowed the owner to utilize the site.
Mr. Chair, Commissioner Hamilton, initially when I went out to the site a couple of years back, I walked the entire hillside, which the applicant had proposed an access point and wanted me to take a look as a courtesy to get to the top. I looked at that, discussed it with my supervisor, who's Paul Cavanaugh, and we discussed it in detail, that this site would be way more detrimental in terms of significant trees, rock outcroppings, slope disturbance, grading and drainage plan would be very, it would create a lot more drainage. And not only that, but this site had maybe possible variances on top for setback and other issues that were at hand, being visible from very many locations along I-25 and Old Pecos and St. Michael's at that. In honesty, if the applicant had access or legal access to the top, for whatever reason, this was done prior to him coming forward with this request, there was a legal litigation on the road, and the applicant does not have access to the top where there is a buildable area. And I feel that if he were to design up there, we can meet the standards with some tweaking of his house or his residence. But that's not possible, and that's why he is building down lower on this lot. This lot area is close off the road, so it would be a lot less of a driveway to create. And not only that, but it's easier to get access to, and it's probably the only area that has the least amount of significant slope besides the top.
So if these variances are approved, and there are 4 variances that are required, correct? that if these variances are approved, what other plans, studies, and other compliances are then going to be required in order to construct a project?
Mr. Chair, Commissioner Hamilton, so what happens is that we're going to request a grading and drainage plan for the entire site, as well as the disturbances and for any of the impervious surfaces that are created as well. And they're going to have to capture the pre and post drainage calculations of the development cannot change. They've got to be on, and it's stated in our code, in one of our sections of our code. That's got to be complied with. As well as all the other conditions of approval. They have to provide a limits of disturbance with construction fencing, showing that they have to be within the confines of the approval. If they are somewhat out of it, then we're talking about a null and void situation here. I mean, it's a moot situation. They can't exceed what they're being granted. So therefore, then they would have to go through you or through the proper realms, I should say, the planning commission and hearing officer once again to get those additional approvals. The applicant felt fairly confident that he can be within those confines, and that's why he created this plan. Basic plan sets, he's going to need elevations. He's going to need what's provided on our permit checklist. He's going to need to provide a permit from the environment department. He'll need to provide a permit from the state engineer's office for the well. And there's minor other, documentation, and perhaps Vicky may be able to chime in a little bit more on that. But I think that's basically the requirement for a residential single family residence.
And so all of those things still will be done. These are variances that are just going to allow this to move forward to have any ability to build. This is as a lot, he has a right to build a well. He just has to get the permit and do all of that with the state engineer's office.
Mr. Chair, Commissioner Hamilton, that is correct on your first statement. He does need this variances in order to move forward, and there is additional requirements in which he'll have to provide with the conditions of approval, as I explained. And then, yes, he will need to provide us an application and approval from the state engineer's office and environment department for the septic system for the water and septic.
And is that consistent with other houses developed in this neighborhood? They're on wells and septic?
Mr. Chair, Commissioner Hamilton, that is correct. It is consistent.
Okay. Well, at this point, at this moment, those are my questions. Thank you, Mr. Chair.
Thank you, Commissioner Hamilton. I'm going to go to other commissioners that have questions. I'll just go one at a time. Commissioner Hanson, did you have any additional questions? No, not at this time. Commissioner Hughes?
No, no additional questions.
Commissioner Garcia? We may have lost Commissioner Garcia. Is Commissioner Garcia still on, Tessa?
Yes, he is. He said he was having some.
Am I here?
Oh,
Yeah, we can
Yes.
hear you, sir. Go ahead.
Okay, good. So really, John Lovato, a great job for your presentation. For an individual that worked in the zoning department for many, many years and did many presentations, great job. You did a great job. Some of the things is that I think that the legal out of record, that's what we do in the zoning department. We make sure it's a legal out of record, and you guys have already done that. And yes, it's a legal out of record. I get it, I understand that. So in regards to the individual, it actually is kind of I hate to say, I want to say the way it is, because these bashing staff, I don't like that. So I just have a little bit of a hard time whenever somebody's there talking down to staff, because I don't appreciate that, because I've been staff many years. So just want to put that for the record. Also, in regards to, we got the legal lot, can I understand that? So these trees, what type of trees are they? Are they like, what are they? Are they willows? What are they? What kind of trees are they? And why are we making a thing about these trees? Are they beautiful trees? They've been there for 25, 50 years. But I just wanted to bring that forward, Mr. Chair. But one of the other things is, yes, as the Vice Chair brought up, they're going to do the environmental stuff, state engineer's office, all that stuff. They have to get all that stuff before they can get a permit for that stuff. But one of the things is, thanks for staff. And I just don't appreciate when people bash staff. So that's what I want to say, Mr. Chair. So that's all I have to say. Thank you.
Mr. Chair, I just wanted to go ahead and answer Mr. Garcia's question. And those, the type of trees that are on there are ponderosas. These are pinon trees and juniper trees and some, you know, moss oak brush, some other similar brushes like that.
Thank you, John. Once again, excellent job of what you guys do, because, you know, people don't realize the zoning department is a very challenging department that we all deal with, whether it's a city, county, state, and so great job, and your staff and your supervisors. Thank you. Thank you, Mr. Chair.
Thank you, Commissioner Garcia. Thank you, Mr. Lobato. If there's not any other questions from the commission, I'm going to go back to Commissioner Hamilton.
Look, I believe that and really appreciate the land use staff having done a very credible job on this. The idea of variances is, in fact, to support those situations where somebody is not able, for reasons just like this, to build on their property without certain variances. All the other protections that are in the code are being followed through on. And I trust that our staff is doing an appropriate job on that. Frankly, I think the Planning Commission probably saw that as well. Clearly, there are a lot of details to be worked out, but the owner is going to be held to complying with all of those rules and regulations. And I appreciate the staff's assurance that that's going to be reviewed. So under the circumstances, I believe the variances are needed to allow rightful property owner to be able to build on his property, that they've gone to a very reasonable effort to try to minimize disturbances and minimize the problems. And so I would like to make a motion to deny the appeal, uphold the Planning Commission's decisions.
Okay, thank you, Commissioner Hamilton. So we have a motion. Do I hear a second?
Clarification of what John said? Am I still allowed to do that?
Second.
Public comment is already closed, sir. And we have a second from Commissioner Hanson. So a motion from Commissioner Hamilton. And if you could clarify, your motion was to deny the appellant's request, correct?
That is correct. And uphold the Planning Commission's decisions to grant the variances.
Mr. Chair, Commissioner Rugbaugh, and commissioners, is that with staff conditions as well?
That's correct. That's affirmative, Mr. Lovato, with staff conditions.
And the second from Commissioner Hanson is the correct, is also the same?
Yes.
Okay, so we have a motion from Commissioner Hamilton, a second from Commissioner Hanson. I'm going to go to a roll call vote. Commissioner Garcia?
Yes.
Commissioner Hamilton?
Yes.
Commissioner Hanson?
Yes.
Commissioner Hughes?
Yes.
And a yes from Commissioner Roybal. So this item is passed, or the motion that was made carries. And so thank you, commissioners. And I want to say thank you to the constituents and also the applicants and appellants that were here today to give their testimony. We really appreciate it. These decisions aren't always easy, but it's something that the commission has to do. So we appreciate you all being here tonight. I'm going to move on to item number D. And this is case number 20-5110, Vista de Sangre Subdivision Conceptual Plan, Preliminary and Final Plat, Extension and Variance, Eliano Company Incorporated. Applicant is requesting conceptual plan approval for a 23-lot residential subdivision, which includes one open space remainder tract to be developed in phase 2 And second in phase 2 and preliminarily and final plat approval for phase 1, 9 lots, and phase 2, 13 lots on a 12.62 acre and a 36-month time extension for phase 2. The request also includes a variance of chapter 7.13 or 0.1.7.1.5 and table 7-19 of the SLDC to allow phase 1 to utilize the existing wells until such time that the community water system is established with a valid water permit. The site is located north of New Mexico 599 frontage road at the intersection of Cayo del Ojo Grant Road within Township 17 North, Range 9 East, Section 31. And this is in Commissioner District 2, which is Commissioner Hansen. And second, the consideration and potential action on affordable housing agreement if preliminary final plat approval is granted after public hearing. And the case manager is Miss Vicky Lucero.
Thank you, Mr. Chair. Can everybody hear me okay?
Yes, we can.
Thank you. So prior to, I'm going to give a little bit of the history on the project to start. Prior to enactment of the SLDC, this property was under the jurisdiction of the extraterritorial zoning ordinance. Under the EZO, the subject property was classified as being within the urban area. In this area, the allowable density was ½ acre per dwelling unit where community water and sewer were being utilized. At that time, the applicant was proposing to utilize community sewer and connect to the county water system, which was anticipated to be extended to the property per 2005 agreement between the county and El Llano Company, Inc. and County Road 62 LLC, which also owned an interest in the property at that time. The property owners were granted approval of a condominium development of 23 dwelling units. Subsequent to that approval, the roads and infrastructure for the entire project were constructed. On September 21st, 2009, El Llano Company, Inc. recorded with the Office of the County Clerk a replat and subdivision for Vista de Sangre subdivision consisting of 22 residential lots based on the previous approval of the condominium development. The plat was never presented to the BCC for review and approval. Rather, it was signed in error by the land use administrator at the time. 8 of the lots in the subdivision were sold, and the county issued permits for 6 of the residences as condos prior to the recordation of the 2009 plat. County also issued permits for 2 additional homes on separate lots under the 2009 plat before realizing that the subdivision had not gone through the proper approval process in order to create a 22-lot Type 3 major subdivision. A Type 3 major subdivision requires approval by the Board of County Commissioners. The 2009 survey plat was approved administratively without going through a public hearing process and without the BCC taking action. Upon this discovery, Santa Fe County determined that this subdivision was not created legally and these lots could not be recognized as legal lots of record. When El Llano Company, Inc. was notified of this determination, a complaint was filed against the board and current administrator in New Mexico State Court, First Judicial Court, and Santa Fe County on January 3rd, 2019. The complaint asserted claims for declaratory judgment, equitable estoppel, breach of contract, breach of duty of good faith and fair dealing, promissory estoppel, and violation of constitutional rights, and also asserted a claim for injunctive relief. In an attempt to resolve the dispute, the parties entered into a settlement agreement and release of claims in August of 2019, and that's in Exhibit 6 of the packet material. The settlement agreement requires the administrator and board to conclusively presume that El Llano has vested rights in the density required to allow a single-family residential dwelling on each of the 22 lots. In addition, the applicant agreed to submit a consolidated application for subdivision approval. The legal proceedings are stayed pending the outcome of the application contemplated by the settlement agreement, which application is the subject of this report. The proposed development is within the residential estate zoning district and is within SDA 2. The applicant is requesting conceptual plan approval for a 23-lot residential subdivision, which includes one open space tract, to be developed in 2 phases, and preliminary and final approval for phase 1, which will consist of 9 lots, and phase 2, which will consist of 13 lots. The applicant is requesting a 36-month extension of the preliminary and final plat approval of phase 2, which will allow them up to 5 years to record the final plat for phase 2. The applicant's request also includes a variance of Chapter 7.13.7.1.5 and Table 7-9 of the SLDC to allow Phase 1 to utilize shared wells until a community water system is established, which will be prior to Phase 2. The use of the shared wells will allow the already occupied homes to continue to receive water in the manner they are currently receiving water. The applicant is developing this subdivision in 2 phases, as the community water system that was installed does not satisfy all requirements set forth in the SLDC. Specifically, sufficient water rights have not been transferred, and therefore the entire subdivision cannot be recorded. 8 homes have been constructed, and in order to allow those 8 owners to have a legal lot of record, the applicant is phasing the development to include all of these lots in phase 1. The applicant is requesting conceptual plan approval in order to phase the proposed subdivision in accordance with Chapter 5.5.4.1 of the SLDC. The applicant has addressed the conceptual plan approval criteria as stated in the staff report. Staff has also responded to the criteria. The applicant is also requesting the variance. Under the SLDC, variance requests are required to go before the hearing officer and planning commission for recommendation and approval. The settlement agreement between the applicant and the county, however, calls for all public hearings related to the Vista de Sangres project, including hearings related to any required variance, to be consolidated and heard in the first instance in one proceeding before the BCC. In addition to being mandated by the settlement agreement, this approach streamlines the approval process while still providing the public an opportunity to be heard on all issues. The applicant is requesting a variance which require a community water system for subdivisions of 5 to 24 lots, whose minimum lot size is less than 1 acre, as well as a valid water right permit from the OSC or a quantity of water to meet the maximum annual water requirements of the proposed development. The applicant is requesting that the Board of County Commissioners allow the subdivision to continue using its statutory domestic water rights established under NMSA 1978, Section 72-12-1, solely for Phase 1 of the subdivision. A fully compliant community water system pursuant to the requirements of the SLDC will be established before recordation of the final plat for Phase 2 of the subdivision. The applicant has responded to the variance review criteria as stated in the staff report, and staff has also provided a response to each of the variance review criteria. The application for preliminary and final plat approval was reviewed for compliance with the applicable standards set forth in the SLDC. Staff reviewed the studies, reports, and assessments, and also reviewed for access, road design, fire protection, landscaping and buffering, lighting, signage, parking, loading, water supply, wastewater and water conservation, open space, protection of historic and archaeological resources, terrain management, operation and maintenance of common improvements, and affordable housing. Recommendation. In regards to the conceptual plan, staff has reviewed this application for a 23-lot residential subdivision to be completed in 2 phases for compliance with conceptual plan review criteria and finds that the application meets the criteria for approval of the conceptual plan. In regards to the variance, staff has reviewed this request for compliance with the variance review criteria. There are 8 existing homes in the development that are currently utilizing the existing wells. The requested variance would allow those 8 homes plus 1 additional home to continue to utilize the existing wells, provided that a community water system be established prior to plat recordation of Phase 2, which would serve the homes in Phase 1 as well. At that time, the variance would no longer be needed, and therefore it would not be contrary to the public interest. If the variance was denied and the final plat for Phase 1 was not recorded, the homeowners in Phase 1 would continue to face uncertainty regarding the legal status of their lots, which would create an undue hardship on those homeowners. Therefore, staff can support the variance request. In regards to the preliminary and final plat approval and 3-year time extension, staff has reviewed the application for compliance with Chapter 5 subdivision regulations, Chapter 6 studies, reports, and assessments, Chapter 7 design standards, and all other pertinent SLDC requirements. The application is in compliance with the SLDC. Staff recommends approval of the request for a conceptual plan to allow a 23-lot subdivision to be developed in 2 phases. Staff recommends approval of the request for a variance to allow phase 1 of the development to continue to utilize the existing wells. Staff also recommends approval of the preliminary and final plat for phases 1 and 2 of the Vista de Sangre subdivision to create 23 lots and a 3-year time extension of the plat approval for phase 2, subject to the following conditions. Mr. Chair, may I enter those conditions into the record?
Yes, you may.
Thank you, Mr. Chair. I stand for any questions.
Thank you, Ms. Lucero. I'm going to go ahead and wait on questions to staff. And is the applicant present?
Yes, I am.
Okay. Mr. Hoyt, is that correct? If you'd state your name and address for the record, and we'll have our esteemed clerk swear you in.
Scott Heft, 48 Paseo Aragon, Santa Fe, New Mexico, 87506.
Please raise your right hand, Mr. Heft. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
For the record, before you testify, please state your full name and address. I realize you just did, but you can state that you understand you are under oath for your testimony to be considered valid.
I am under oath. My name is Scott Heft. My address is 48 Paseo Aragon, Santa Fe, New Mexico, 87506.
Thank you.
Thank you very much. I'm sorry.
No, go ahead.
Okay. So I have a brief presentation this evening. I just was going to take a little bit of time and summarize what Vicki just went through because it's long and it's complex and there's a 4-year history on this project. I'll take about 5 minutes of your time. So first of all, I am Scott Heft. I'm the land planner for the project and I've been associated with this for the last 4 years, assisting the owner get through this hurdle for this project. Kyle Harwood is also on the video conference. He's from EGOF, Fairlick, Martinez, and Harwood, and he is available to field any questions regarding water or water rights. Travis Jackson is also on the video call. He's from Jackson and Lohman Law Firm, and he can field any questions regarding the settlement agreement or of any of the procedures over the last 4 years. And then also Kate Fishman is on the call or on the video call, and she is the owner. And again, all are available to field questions. They are not making presentations this evening. And so first of all, we'd like to thank Vicki and Pinellas Green. This has been a long haul. It's been 4 years to get to this point, believe it or not. We started off in 2017, and with an inquiry regarding water rights for the project and how do we proceed. And 2019, we found ourselves completing a settlement agreement for the project. It took 2 years just to get to the settlement agreement. And in February of 2020, another year later, and a little longer, we went ahead and made the submittal. And so let me just quickly summarize. The settlement agreement directed us to make a submittal on this project, which is complete, essentially, from an infrastructure standpoint, from a home standpoint. The question, of course, is the legal lots. And so we were required, as part of the settlement agreement, to complete this submittal and take it to the BCC for public hearing. And this process took from conception of starting the submittal to actually completing it and getting it into review about 1 year and 3 months to get to this point to date. And that was several rounds of submittals with the staff and the reviewing agencies. So it took some time to get this submittal right for this evening. There's been a lot of work to get this. And if you think about it, you know, we've been at this for 4 years and we've got this pretty much narrowed down to 18 conditions of approval, and of which 17 of those agree and 1 we have a minor correction to. And so that's quite an accomplishment of where we've been on this project. The other item to highlight is the fact that there's 8 existing property owners on this project. So for us to proceed with this, we needed their approval. We needed their concurrence, and they've been a pleasure to work with. They've been extremely encouraging and cooperative throughout the entire process. And so to the submittal itself was 4 pieces. It was a conceptual, which is consistent with the SDLC. It was a conceptual plan, which Vicki pointed out. It was preliminary plat and final plat. And preliminary plat, because you need a preliminary plat before you submit a final plat. And then a variance. And the variance is because we have 2 phases. And the variance is needed because we have water for the first phase, phase 1, for the first 9 lots. And we need that to be able to proceed to get those lots recorded in phase 1 before we can proceed with phase 2. In order to get phase 2 recorded, we need to transfer the water rights. And so the other element of this application this evening is the time extension. And so we need an additional time, which is part of the application tonight, 36 additional months for 60 months total, in order to have the time to transfer the water rights so we can record phase 2. So going forward here, the process is going to be, we are going to, if we get approved this evening, within 60 days, we have to record phase 1. Those are the first 9 lots. Then the water rights transfer process will proceed, and hopefully within a 2-year period of time, we will have that completed. We will then proceed to record phase 2 of the project, and then development permits for the homes and for the affordable homes will be proceeded with once phase 2 is recorded. So in this period of time, though, we also have to consider the condition of approval. So there was a condition of approval, which is number 10, which we have a slight concern with, which is it's a minor tweak. Overall, as said, we agree with all 18 conditions of approval with the exception of a minor tweak on the 10th condition. And that is that the condition stated that we needed to build the expansion of the storage pond, the ponding area, which you can see on the plan that's on screen, ponding area. We needed to expand that for the development of phase 2. And the requirement is that they needed to be constructed, to be finalized prior to us submitting for the plat for phase 2. When in fact, we're just simply asking that we can post a letter of credit for those improvements, record phase 2, and then do the improvements once phase 2 is recorded and we're proceeding with the development for the homes and for the balance of the construction. And so why we're requesting that is because as part of the settlement agreement, section number 5 states that we're not required to do a letter of credit or bonding. And so I'm making this request of staff so that we can go ahead and proceed to get a letter of credit as an option for condition number 10. So in sum, I essentially stated where we were, which 4 years ago, 2017, was a long way away from where we're at now. And essentially through this submittal process of taking us 1.5 years, we got to the point to where we have a complete submittal. And now from this point forward, if we can get your approval and if we can get the plat recorded, the existing homeowners will be satisfied with their approved lots, and we can proceed with the water rights transfer, and then in the next year or 2 or 3, record phase 2. And again, that additional time is needed for that extension. It's part of the request this evening, so that we don't have to come back for an approval. So with an approval of a preliminary plat, we have 2 years to record the final plat. And if we don't record the final plat within 2 years for phase 2, then we have to come back and ask for another extension, or for an extension. And we're circumventing that rather than having to come back for an extension again. If we have trouble with the water rights transfer, we would have the extension granted tonight so that we would save us the issue down the road. And with that, I stand for questions as well as the team.
Okay, thank you, Mr. Heft. I don't know if you wanted to call any other witnesses or any of your other team members to comment as well, or just be available for questions. But I'll leave that up to you if you want that to be your presentation and you didn't have any other witnesses at this point.
We are good, Commissioner.
Thank you, Mr. Heft. Okay, so we're gonna go to, next to, well, actually, I'm gonna go to public comment. Is there anybody, from the public that is signed up to, speak on this item, Tessa?
Yes, Mr. Chair, William Me is.
Okay, and, what I'm gonna do is, if there's anybody else from the public that would like to, comment in, support or opposition of this, request, if you could state your name so that we can, go ahead and include you on public comment. And if you're a call-in participating by phone, you can hit *6 to unmute yourself. So once again, is there anybody else that would like to speak relative to this item besides Mr. William Me? Okay, hearing none, we're gonna go ahead and close public comment and we'll call on Mr. Me. Mr. Frescus, did you have a comment, sir?
Yes, I apologize, Mr. Chair. It looks like somebody raised their hand in the Steve. There's no last name tied to it, but I think they want to speak up for public comment.
Did you say Steve?
Steve. Stephen, yes.
Stephen, oh, okay. Okay, Tessa, so it looks like we have two speakers. And if we could go ahead and start with Mr. Me.
Hello.
If you could state your name and address and be sworn in by our county clerk, Mr. Me.
Okay, it's William Me with Albertville Village Association, and my address is 2073 Camino Samuel Montoya, Santa Fe, New Mexico 87507.
Hi, Mr. Me. We can rely on you that you've raised your right hand.
Oh, okay. Let me. Yeah. Okay. There I am.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
For the record, before you testify, please state your full name, address, and that you are under oath for your testimony to be considered valid.
William Me, 2073 Camino Samuel Montoya, Santa Fe, New Mexico 87507.
And you're under oath.
And you acknowledge you're under oath. Okay.
Basically, we were sent a letter to the Albertville Traditional Historic Community Organization, and we reviewed the packet. We did have some questions on the water issues, but in reviewing the packet, it makes it muddier. No, I made it clear, and we have no other issues with the development.
Thank you, Mr. Me. So you are in, the organization is in support of the development?
I guess we would take no position in opposition.
Okay, thank you, sir. And I think we had Stephen also wanted to comment. Sir, if you can be sworn in by our county clerk.
Sure. Steve, will you raise your right hand? And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
For the record, before you testify, please state your full name, address, and that you are under oath for your testimony to be considered valid.
Sure. My name is Stephen Pattinson, 29 South Cayo de Oro, Santa Fe 87507. I am in full support of this. I am a homeowner.
Sir,
Yes.
will you state that you are under oath? I'm
Oh,
sorry.
sure. I am under oath. Thank you.
Thank you.
And that I am in full support. I am one of the 8 homeowners that currently bought 6 years ago. We went through everything legally. One of the biggest investments of my entire life. And to find out that it was a mistake a long time ago by somebody at the county was just overwhelming. So I really hope that this gets resolved. Thank you.
Thank you, Mr. Haddinson. Okay, so we don't have any other public comment, so I'm going to close public comment and I'm going to go to commissioners. This is in Commissioner District 2, Commissioner Hanson. Would you like to start us off, please? Commissioner Hanson, would you like to start? This is your district.
Yes, thank you. I keep getting kicked off, as you know, so it's only happened like 10 or 15 times today.
I know it can be frustrating.
Thank you for the presentation. Thank you, William, and thank you, Stephen. My question is on item 10, the size of the existing pond shall increase to 2.6 acre feet in volume. So you don't want, how big do you want to make the pond?
Commissioner Hanson, the pond will increase that volume, the 2.6 acre feet of the capacity. So the issue on the size of the pond, the issue is not the size of the pond, it's when it will be constructed. And so we were requesting as part of that condition that we can either build it or bond for it prior to recording. So it's stated right now that we have to build it, complete it prior to recordation. And we're requesting that we can either build it prior to recordation of phase 2, or we can post a letter of credit for it, those improvements prior to recordation of phase 2.
Okay, Vicki, how do you feel about that?
Mr. Chair, Commissioner Hanson, because it's a request by the applicant rather than a requirement by the county, and the applicant has acknowledged that he will not consider it to be to constitute a breach of the settlement agreement. I think staff would be in agreement with that condition, with the addition, an additional statement just stating that development permits for phase 2 will not be issued until the pond is fully constructed.
Okay, I can go for that. How about you, Scott? You're muted.
Yes, Commissioner Hanson, that's acceptable.
Okay, so I want to make a motion to approve the Vista de Sangre subdivision conceptual plan, preliminary and final plat, extension and variance, and which includes all of the conditions. Anything else I need to say, Vicki, and the condition that you just commented on that will be in the final order?
Mr. Chair, Commissioner Hanson, I think you've captured everything.
Okay.
I'll second.
So we have a motion from Commissioner Hanson, a second from Commissioner Hamilton. I'm going to go to a roll call vote. Commissioner Hanson?
Yes.
Commissioner Hamilton?
Yes.
Commissioner Garcia?
Can you all hear me really quick?
Yes, sir.
So really quick, this is an interesting project. This happened in Vicki, very good job. You did it right to the point, and great job, Scott. You and your team, great job, because this has been around since 2000, and it was an interesting thing because, as Vicki knows this, and Penny, and everybody else in land use, is this is the type of project that actually we did a transfer of development rights. So one of the questions I have is those TDRs. Are they still there, or where are they going? Question on that. But once again, with the settlement agreement, we've talked about this as County Commission with Manager Miller and her team, as into this is where we're at right now. But great job. So let me see where else I just think the question I have is the transfer of development rights, because we did. This is one of the first properties we did transfer of development rights back in the days, back in 2000. So what happens with that stuff? Question. And once again, Vicki, great job, awesome job, and Scott, you and your team, great job. And so, so we will not get phase 2 or 3 till we have to have a water system through there, correct? So those are 2 questions I have. Thank you once again.
There is no phase 3. There's only phase 2.
So this has been around for a while. Before 599 was there, they got zoning from the gentleman from Espanola got this zoned out there. But however, so what happened with the transfer of development rights Vicky, that we approved this property for, and where do those go? Or are they still there? They're not there anymore. And once again, that's what those questions I have. Thank you. But great job, Vicky, and Scott. Great job for what you've done.
Okay, Commissioner Garcia, is that a yes on the vote, sir?
Yes, that's a good. Yes, yes, it is. So yes. But I just have
Okay,
those questions. I want to put them on the. I want to put them on the record.
Did you have any answers for those questions that Commissioner Garcia asked, Ms. Lucero?
Mr. Chair, Commissioner Garcia, you're correct. This property actually was part of the Transfer of Development Rights Program at one time. And they actually had applied for a subdivision in a different location where they were transferring those rights. But that project never came to fruition. So, so as far as I understand it, that there are no longer transfer development rights now that this project is being developed. And that may have been part of the original agreement for the original approval for the condominiums.
Okay, no, I understand, but I appreciate it. Just for the record, so we understand it. Thank you, Ms. Lucero, but great job. And the consultant, great team you have together. Great job. So thank you, Mr. Chair. Appreciate that.
Thank you, Commissioner Garcia, and thank you for enlightening, giving us some history on this. We appreciate it. Commissioner Hughes?
Yes.
And a yes from Commissioner Roybal. So this item passes unanimously. Thank you and congratulations. We look forward to seeing this subdivision move forward. Thank you, Mr. Heft. We appreciate you being here tonight.
Thank you very much.
Staff. Thank you to staff for the great job. Mr. Mee, good seeing you, sir. Okay, so
really quick, Mr. Chair, Mr. Mee, thank you for hanging in there and watching what's going on, eyes and ears in the community, because that's what we need, and you do an excellent job. Thank you, Will and me. Appreciate that.
Yes, sir. Thank you for acknowledging that as well, Commissioner Garcia. We're going to go on to item number 12, which is concluding business. Are there any? Yes. Go ahead. Vicky, I'm sorry.
I'm sorry. There is another part to this application, which is approval of the affordable housing agreement.
Oh, okay. Sorry about that.
No problem. And that's in the packet material also as an attachment.
Okay. Mr. Chair.
Yes, Commissioner Hudson, go ahead.
So my question on the affordable housing agreement, are both of the affordable housing units going to be in phase 2?
Mr. Chair, Commissioner Hanson, they were proposing to do one affordable housing unit in phase 1 and one in phase 2.
Okay. That's acceptable. Is there anything else I need to know about the affordable housing agreement?
Mr. Chair, Commissioner Hanson, it's they're meeting the 8% requirement in the SLDC, and the affordable housing agreement has been signed by the applicant and by the legal department. So yeah, it's just awaiting your approval if
okay. I move to approve the affordable housing agreement. And also thank you, Vicky, for all your work on this project, and to Penny Ellis Green and to the entire county staff for their dedication to resolve this issue.
And I'll second.
Thank you, Commissioner Hanson. So a motion from Commissioner Hanson and a second from Commissioner Hughes. Once again, we're going to go to a roll call vote. Is there anything else under discussion before we go to that roll call vote? Okay, hearing none, I'm going to go to a roll call vote. And once again, this is for consideration, and it was for the action of affordable housing on this agreement. Commissioner Hanson?
Yes.
Commissioner Hughes?
Yes.
Commissioner Garcia?
Yes, Mr. Chair.
Thank you, Commissioner Garcia. Commissioner Hamilton?
Yes.
And a yes from Commissioner Roybal. So we do have both items number 1 and number 2 that have been approved on 11D. And so thank you, commissioners. We're going to go ahead and move on to our item number 12, which is concluding business. Does anybody, any of the elected official or board members have announcements that they would like to make before concluding business? Or has everybody talked enough? I know it's been
I want to say good night to everyone.
Yeah, definitely.
Mr. Once again, it's really late, but I would like to thank the county staff. I was there on Saturday planting trees for Earth Day in the Edgeworth Community Center, and our staff did an excellent job as well as the volunteers. And so just want to thank him and do a shout out to them. But yes, thank you, Mr. Chair.
Thank you, Commissioner Garcia. Okay, Daniel, I thought I saw your hand go up, or did you have something else to let us know?
I just wanted to add to your comment about the shirts of "You're on mute."
Yeah.
I think also we should have another shirt that says, "I'm calling regarding your car's extended warranty."
You know, Mr. Chair, just on that note, I get calls from the companies all the time for my truck, and they say, well, that truck burned down like 2.5 years ago. Oh, did it? Yes, it burned down. So I don't need an extended warranty, but I know what you're saying, Daniel. But,
There you go. Just be like me and say you have a 1980 Honda that you'd like to get extended insurance on. Okay, so if there's not any other announcements, I would echo what Commissioner Hansen said, and good night to everybody, and thank you for hanging in there. It's been a late night. I'm sorry we didn't get out earlier, but it is what it is. We all signed up for this, so thank you all for hanging in there. I'll entertain a motion for adjournment.
So moved.
So we have a motion
Second.
from Commissioner Hansen, a second from Commissioner Hamilton, a very enthusiastic second. And all those in favor signify by saying bye. Good night, everybody.
Bye.